Rule 26. Admission by adverse party. Section 1. Request for admission. At any time after issues have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document described in and exhibited with the request, or of the truth of any material and relevant matter of fact set forth in the request. Copies of the document shall be delivered with the request unless copies have already been furnished. Section 2. Implied admission. Each of the matters of which an admission is requested shall be deemed admitted unless, within a period designated in the request, which shall not be less than 15 calendar days after service thereof, or within such further time as the court may allow on motion, the party to whom the request is directed files and serves upon the party requesting the admission a sworn statement, either denying specifically the matters of which an admission is requested or setting forth in detail the reasons why he or she cannot truthfully either admit or deny those matters. Objections to any request for admission shall be submitted to the court by the party requested within the period for and prior to the filing of his or her sworn statement as contemplated in the preceding paragraph, and his or her compliance therewith shall be deferred until such objections are resolved, which resolution shall be made as early as practicable. Section 3. Effect of admission. Any admission made by the party pursuant to such request is for the purpose of the pending action only, and shall not constitute an admission by him or her for any other purpose, nor may the same be used against him or her in any other proceeding. Section 4. Withdrawal. The court may allow the party making the admission under this rule, whether express or implied, to withdraw or amend it upon such terms as may be just. Section 5. Effect of failure to file and serve requests for admission. Unless otherwise allowed by the court for a good cause shown and to prevent a failure of justice, a party who fails to file and serve a request for admission on the adverse party of material and relevant facts at issue, which are ought to be within the personal knowledge of the latter, shall not be permitted to present evidence of such facts. Rule 27. Production or inspection of documents or things. Section 1. Motion for production or inspection. Order. Upon motion of any party showing good cause therefor, the court in which an action is pending may a. Order any party to produce and permit the inspection and copying or photographing by or on behalf of the moving party of any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things not privileged, which constitute or contain evidence material to any matter involved in the action, and which are in his or her possession, custody, or control. Or b. Order any party to permit entry upon designated land or other property in his or her possession or control for the purpose of inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. The order shall specify the time, place, and manner of making the inspection and taking copies and photographs, and may prescribe such terms and conditions as are just. Rule 28. Physical and mental examination of persons. Section 1. When examination may be ordered. In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may in its discretion order him or her to submit a physical or mental examination by a physician. Section 2. Order for examination. The order for examination may be made only on motion for good cause shown and upon notice to the party to be examined and to all other parties, and shall specify the time, place, manner, conditions, and scope of the examination and the person or persons by whom it is to be made. Section 3. Report of findings. If requested by the party examined, the party causing the examination to be made shall deliver to him or her a copy of detailed written report of the examining physician setting out his or her findings and conclusions. After such request and delivery, the party causing the examination to be made shall be entitled upon request to receive from the party examined a like report of any examination previously or thereafter made, of the same mental or physical condition. If the party examined refuses to deliver such report, the court on motion and notice may make an order requiring delivery on such terms as are just. And if a physician fails or refuses to make such a report, the court may exclude his or her testimony if offered at the trial. Section 4. Waiver of privilege. By requesting and obtaining a report of the examination so ordered or by taking the deposition of the examiner, the party examined waives any privilege he or she may have in that action or any other involving the same controversy regarding the testimony of every other person who has examined or may thereafter examine him or her in respect of the same mental or physical examination. Rule 29. Refusal to comply with modes of discovery. Section 1. Refusal to answer. If a party or other deponent refuses to answer any question upon oral examination, the examination may be completed on other matters of adjourned as the proponent of the question may prefer. The opponent may thereafter apply to the proper court of the place where the deposition is being taken for an order to compel an answer. The same procedure may be availed of when a party or a witness refuses to answer any interrogatory submitted under Rule 23 or 25. If the application is granted, the court shall require the refusing party or deponent to answer the question or interrogatory, and if it also finds that the refusal to answer was without substantial justification, it may require the refusing party or deponent or the counsel advising the refusal, or both of them, to pay the proponent the amount of the reasonable expenses incurred in obtaining the order, including attorney's fees. If the application is denied and the court finds it was filed without substantial justification, the court may require the proponent or the counsel advising the filing of the application or both of them to pay to the refusing party or deponent the amount of the reasonable expenses incurred in opposing the application, including attorney's fees. Section 2. Contempt of court. If a party or other witness refuses to be sworn or refuses to answer any question after being directed to do so by the court of the place in which the deposition is being taken, the refusal may be considered a contempt of that court. Section 3. Other consequences. If any party or an officer or managing agent of a party refuses to obey an order made under Section 1 of this rule, requiring him or her to answer designated questions, or an order under Rule 27 to produce any document or other thing for inspection, copying, or photographing, or to permit it be done, or to permit entry upon land or other property, or an order made under Rule 28 requiring him or her to submit a physical or mental examination. The court may make such orders in regard to the refusal as are just, and among others the following: A. An order that the matters regarding which the questions were asked, or the character or description of a thing or land, or the contents of the paper, or the physical or mental condition of the party, or any other designated facts shall be taken to be established for the purposes of the action in accordance with the claim of the party obtaining the order. B. An order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting him or her from introducing in evidence designated documents or things or items of testimony, or from introducing evidence of physical or mental condition. C. An order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding or any part thereof, or rendering a judgment by default against the disobedient party, and letter D, in lieu of any of the foregoing orders, or in addition thereto, an order directing the arrest of any party or agent of a party for disobeying any of such orders, except an order to submit to a physical or mental examination. Section 4. Expenses on refusal to admit. If a party, after being served with a request under Rule 26 to admit the genuineness of any document or the truth of any matter of fact, serves a sworn denial thereof, and if the party requesting the admissions thereafter proves the genuineness of such document or the truth of any such matter of fact, he or she may apply to the court for an order requiring the other party to pay him or her the reasonable expenses incurred in making such proof, including reasonable attorney's fees, unless the court finds that there were good reasons for the denial, or that admissions sought were of no substantial importance, such order shall be issued. Section 5. Failure of party to attend or serve answers. If a party or an officer or managing agent of a party willfully fails to appear before the officer who is to take his or her deposition after being served with a proper notice, or fails to serve answers to interrogatories submitted under Rule 25, after proper service of such interrogatories, the court on motion and notice may strike out all of any part of any pleading of that party, or dismiss the action or proceeding or any part thereof, or enter a judgment by default against that party, and in its discretion or order him or her to pay reasonable expenses incurred by the other, including attorney's fees. Section 6. Expenses against the Republic of the Philippines. Expenses and attorney's fees are not to be imposed upon the Republic of the Philippines under this rule.